Thanks to Bug Zero for supporting this episode. We appreciate services that are low-key and predictable. Bug Zero's Insectishield plan is both. It keeps your home pest-free without knocking your day off track. And the people, they are super kind. Check them out at bugzero.com or give them a quick call or text at 417-831-7378. The number again is 417-831-7378.
Just a quick disclosure to share in conjunction with this podcast. Each of us are speaking to our personal experiences and do not consider ourselves experts and cannot offer medical, therapy, financial, or legal advice. We represent a wide range of experience on the autism spectrum and will always honor each perspective that is brought to our discussions. Our experiences, opinions, and perspectives are all unique and different and will be celebrated. Thank you so much for listening and connecting with us. Thank you. Welcome to Navigating Adult Autism. We are just a bunch of moms with a lot of perspectives, a lot of experience, and a lot of opinions. My name is Mary, and I am here with Elizabeth, Dawn, Tara, and Heather. And our guest is James Ballard. And James is Vice President and Private Client Advisor with Commerce Trust, a division of Commerce Bank. He serves as Senior Consultant and Relationship Manager, providing clients with personalized, objective advice and oversight across all of our services, including trust administration, financial advisory services, private banking, and investment management. Before James joined Commerce, he's practiced law, focusing his practice on estate planning, probate, and trust administration. Maybe I forgot something in there. Right. Was that right? Okay. Well, we're happy you're here. So we're just talking about our adult children with autism and how we should plan for a future, what we should do and what we shouldn't do. So of the parents here, Heather, are you the only one that has guardianship right now?
Oh, we have full guardianship.
You have full guardianship? Are you the only one here that has full guardianship? Or do you have...
Right. Yeah, I don't have guardianship, but my husband and my father have guardianship over Nathan. So
okay.
I'm very involved in that part.
Yeah. Right. So, James, do you want to touch on guardianship right now, or like what the difference is and when someone should have it? Or, and then I know there's some guardianship questions as well. So,
yeah, absolutely. First off, thank you for having me.
Sure.
And just, you know, a little background. So I did, like Mary, as you mentioned in my bio, I practiced law for about 10 years before joining the trust company. And so in that capacity, I did represent individuals through guardianship.
Okay.
I don't do that any longer at the bank in my current capacity, but I'm more than happy to kind of share my thoughts on that. And kind of from my experience prior to joining Commerce as well.
Okay.
As far as, you know, whether or not to pursue guardianship, I mean, that is going to be a question that is completely dependent on the facts and circumstances of just the different individuals involved. There are pros and cons to doing a guardianship. So, you know, maybe some reasons against doing a guardianship, maybe the cost of the proceedings, they're time consuming. And then once a guardianship is in place, it is difficult to terminate. Okay. It's not impossible to terminate, but it is difficult to do so. And so you just have to, you know, be confident as you can be in the decision that, hey, this is the best option available for that person that we are trying to become guardian over. And sometimes there's just no other alternative. If possible, you know, my thoughts on that would be, you know, if the person that you're wanting to become guardian over, your son or daughter, they're over the age of 18, if they have the ability to understand and execute on a durable power of attorney for finance and healthcare, that's where I would start really any conversation with somebody with adult child with autism is starting there. Now that's not always going to be a possibility though.
I see. Go ahead, Dawn.
Yeah. So then what are some of the positive things that happen with guardianship?
Well, you do have more control, and you have kind of the court authority behind you, and so you essentially have the ability if your child does not have the ability to kind of direct care themselves or take care of their finances without running into difficulty, that you would have the backing of the court and the authority of the courts for placement purposes. You'd be able to direct conversations with banks and attorneys as your child's guardian. But for me, it's going to be probably the last stop on the road. First, I'm going to look at those power of attorney documents if you're able to act on their behalf before going down the guardianship road. For a lot of folks, it may be the only option. It ultimately depends on that person. Even if someone has the capacity maybe to execute a durable power of attorney or a healthcare power of attorney, perhaps those power of attorney documents can't be broad enough, and you need court intervention to give you the ability to direct care or placement. Or perhaps your son or daughter just may not want to execute one of those, but it's clear that they are incapacitated and need assistance.
Mm-hmm. Elizabeth?
I have a question on that. So say you have somebody that has maintained their guardianship and you're looking at this power of attorney for the health care, but say they are agreeable and they allow you to be involved and they're making all the right choices and you trust that, that they're going to involve you but at some point, there's an accident or they're incapacitated. Do you need that if you are the next of kin? So that was my question. Do we go through the trouble of doing a power of attorney if they're always agreeable to, taking your advice and working with you on that healthcare, or they can manage it on their own, but say they are in a position where somebody would need to speak for them, but do we actually need that document, or are we just, as parents, the next of kin and don't need that document? That's one question I've always had.
Yeah, that's a great question. In my opinion, I would always advise clients, regardless of capacity, I'd encourage them to, as a foundation document, to have those durable power of attorney for finance and durable power of attorney for healthcare in place. You usually will run into less issues. Most people don't end up don't have the need for those to be used in practice, but they are a backstop. So I always encourage clients' children upon turning age 18 to get durable power of attorney and a power of attorney for healthcare. It gives that person the ability to choose who they want to be making healthcare decisions, and then it makes it easier on the physicians and or financial institutions
True.
Who you may be having to work with in the future.
Oh, okay, that's wonderful. That's a very great advice. Now, with that same power of attorney, you can't, if you're granted power of attorney and you're in the same room, whether it's financial or health, you can't override what that individual says. Is that correct?
That is
you
correct.
You can speak
so
while they're not there or on behalf of them, but okay.
Right. So you're acting in an agency capacity. So you're just their agent. So they are kind of the principal. And through that document, they'd be directing you on how to proceed. So they could kind of overrule you by making those decisions. So sometimes when that is happening, and you believe these decisions are, not in their best interest and maybe harmful to them, at that point, that's when you would look to the guardianship route at that point.
Okay. Dawn, do you have another question?
Yeah. My son is in the middle of the spectrum and he's over the age of 18. And we chose not to take guardianship for some of the reasons you've already articulated. But there are times where if he gets mad at us and says things like, I'm out of here if you make me pay rent or, something along that line. So
Sounds like a typical 19-year-old.
yeah, except he's 28. But, if he would choose to, hop a bus.
Right.
And so I don't have guardianship. I would have no recourse, legal recourse of at least police officers or whatever getting involved and bringing him back.
That's true. Good point. Is that right, James?
And that would be a challenge, correct? Now, a guardianship isn't something that is just automatically granted. So that would be just something to also keep in mind.
Right.
I mean, there are many people out there that obviously live their lives with autism and other situations and never require a guardianship, and probably would never be, a court may never authorize the guardianship. So essentially you're kind of looking at whether or not, I kind of look at this as like a functional approach. And so looking at, whether or not a guardianship should be imposed, you're focusing on whether or not that person's behavior and maybe ability to perform certain activities, maybe even going as far as saying activities required to survive, such as communicate decisions about their health, care about, whether or not they can prepare food, feed themselves, manage their money. If the answer to that is no, they cannot communicate those decisions in that way, and that by doing so they are harming themselves or possibly others, then yes, that guardianship would be in place. But I have seen it where courts, they will allow people to be eccentric. Being eccentric, a need for a guardianship. Okay. But at some point it does cross over to that line, and those are just difficult parenting situations. It's a struggle.
I have no doubt that a court would grant guardianship if I petitioned for it. My son's very capable in many ways, and it was a tough decision. But ultimately, we chose not to, and to bet on him. Now, let's say, God forbid, he gets in trouble with the law, and let's say he commits a felony. Does the guardianship protect him in any way?
That's a good question. I never had that come up in practice. Now, in general, a guardianship is not going to be a shield. And so they are still people, and they are still responsible for the decisions that they make as individuals. So they could, in my opinion, still be prosecuted for crimes if they are committed, even if they are under guardianship. Now, the question becomes at that level, and again, I never practiced in a criminal court, but where does the capacity piece come into play, and the element of the crime that the prosecutor would be accusing them of? And so if they didn't know they were committing the crime or different things like that, or they have a capacity problem, that could play into whether or not, how the charges are ultimately decided. But they could still end up, getting in trouble. So it's not a get out of jail free card. Just under a guardianship.
Yeah, I like your term that guardianship is not a shield. Yeah. Go ahead,
Right.
Dawn. Go ahead, Dawn.
And so another follow-up question. God forbid my son commits a felony and the state takes a look at his parents and say, this is a serious problem. You're not doing a good enough job. We want guardianship. Has that ever happened?
That the state takes over
That the
state takes guardianship.
The state
'Cause I was
takes
gonna say that-
guardianship
from a parent.
and puts a child under a public administrator's care. Or
You mean assuming you had guardianship and this situation happened? Is that what you're saying?
no, assuming
Well,
that
it could be with or without.
With or without.
Yeah, with or without.
Well, I mean, without, they wouldn't. I mean, I wouldn't see how that would come into play. They would just be, you're either
Well,
a
if they're
guardian
saying
or
they're
you're
not doing a good job, Dawn is saying if
But if they're over 18 and you don't have guardianship, then it's not your responsibility. Do you see what I'm saying? Like, they're considered adults at 18.
Oh, yeah.
That's why you
I see what
get
you're saying.
guardianship.
the courts are going to look at kind of this priority, and I believe in the statute here in Missouri, they'll look at parents first, and they'll kind of go down the line with family before ending up with a public administrator.
Oh, okay.
I've known public administrators and have had conversations with them. They are also kind of the last resort for if there's nobody else who is capable of serving to step into that position.
Or willing too, wouldn't you say? They have to be willing. Yeah.
Well, absolutely. So they would step in there. Now, if you were a person's guardian and that ward had committed a crime, that doesn't necessarily make you liable for that crime or have you removed as that person's guardian. They would be looking at whether or not your actions kind of met with the standard of care expected from a reasonable person. And so now if you allowed your child to have a weapon and they use that weapon in a crime, in that situation, it potentially could be looked at as, well, maybe that wasn't reasonable because you allowed this person who has capacity concerns to handle this weapon without, supervision or whatever the case may be. But in general, they would look to family first, specifically parents. And if they were unwilling or unable to do that, maybe the parent has a criminal background themselves or is in prison or has drug addiction issues, they may not be fit. And a court may deem them unfit, and then they'd kind of go down the line until they end up with the public administrator.
So if a public administrator is already, the guardian, and then family or maybe a distant relative, steps up, because I've had a family that I know just asking some questions. And so the person's already under the public administrator, and can that family petition for guardianship? And what does that look like? They just petition the court?
Correct. I mean, you would want to make sure you're having conversations with your attorney, but that family would be having conversations with their attorney. But yes, I mean, there are ways to petition the court to become a guardian and conservator.
So it almost sounds like with your tone that maybe that's not uncommon.
I myself have not experienced that, but it is possible.
It's not out in left field.
No. It just again depend on the kind of the facts and circumstances. Absolutely. Yeah.
Can I mention one thing about that? So in our case, so we have full guardianship, which Zachary has profound autism. There was no question. We just soared through that process. But in our trust, right, and special needs trust, and I know we'll talk about that in a little bit, but we have named successors to us for like being in charge of Zachary's finances and things like that. And what I understood too, and I just thought I'd ask you, those people too, like just because I name Aunt so-and-so as the next, like they still have to petition the court and they have to be approved to continue that process along. Is that correct?
Are you talking about under a guardianship?
Yes. Yeah. Cause we have full guardianship. So to say that, Aunt Christina is going to automatically get to do it is not correct. She would have to petition the court just like we did.
Oh, really?
That is correct.
Yeah.
Now they would take your
recommendation.
Your recommendation, absolutely.
Yeah.
So that's true to you for.
Oh, I didn't know that.
Your minors as well. So, for example, I've got 3 littles, 9, 6, and 4. And so if something happens to my wife and myself, in our last will and testament, we have guardians that are named in there to be the guardian for our children. Now, they don't automatically step into that role. So they would have to admit that will to the probate court and then follow up by opening.
I don't think many people realize that, honestly.
I don't think so either. I thought it was just a given.
Right.
No, I did too.
That if the parents said it is, but they have to petition the court. Wow.
Right.
Interesting.
Absolutely.
That's really
But they could take custody unofficially, right? Would they have?
Correct. And that's the practical side is someone's going to be taking custody of the child.
Yeah.
However, in order to actually have legal authority to act on them. That only comes from the courts.
Wow.
Okay.
Because still, even now, like if I'm going to Zachary's appointment or I'm trying to talk to an insurance company, they always ask me for my guardianship papers. They won't talk to me otherwise.
Okay.
Yeah.
So always have your guardianship papers handy.
I carry them with me everywhere.
Do you?
I
Okay.
do.
Yeah. You like to hear that, don't you, James? That she has them with her. That's good.
Good stuff. Absolutely.
That's good. Go ahead, Dawn.
Yeah, I have another God forbid question.
She's really preparing for the worst.
I lie awake at night thinking of what. No. Let's say my son gets on the internet and orders $10,000 worth of junk or any other type of legal contract or getting conned or whatever. If he was under guardianship, would that help the situation? I mean, if you're under guardianship, are you allowed to enter into legally binding contracts?
That's a little bit of a loaded question. Not loaded, but a little bit of a more complex question. So a guardianship, at least here in Missouri, that's just regarding the person. So you have control over the person. So if you're just in a guardianship, that means you're making essentially healthcare and placement decisions for that person. And so you'd have to, in Missouri, have both a guardianship and a conservatorship over that person. So that conservatorship in Missouri is essentially for the money or the assets.
Okay.
Now, if you have conservatorship of that person, then they do not, again, I would talk to your attorney, but it's my understanding that they would not have the ability to contract. However, that doesn't mean that third parties are going to know that somebody is under a conservatorship. And so if that's the case and they're under the conservatorship, it would not be my recommendation that protectee, that person under conservatorship, should have access to the debit card or the credit card or the funds. So that should be controlled by the conservator, and they would have the access to the funds.
Okay, so the conservatorship is financial.
Correct. Now, some states are different. There's not a federal guardianship law. These are all very state specific. So some states are going to be different than others on how they define incapacity and the requirements for it. But in Missouri, it's kind of bifurcated. There's the guardianship of the person, and then there's the conservatorship of the assets.
Oh, wow. Okay.
Does that create problems? I mean, I can't imagine, trying to move from Missouri to another state or whatever. I was just thinking out loud if this was something that the disability community needs to put a spotlight on and try to bring uniformity.
Policy change.
Yeah, policy change for the whole nation. This is such a complicated, at least to me, to maybe unify it a little bit across the nation would help the disability community.
Absolutely. I think that's a great question. So there are efforts in other areas of the law. And again, it's been a few years. So in 2020 is when I joined Commerce Trust, and my role there has been more of a trust officer and kind of advisor to clients. So I have not been in the guardianship realm really since that time, other than just in conversation and guidance and encouraging my clients if there's a guardianship question or need to go to their attorney and for legal guidance. But there are uniform laws in other areas. So there is a uniform probate code, but not every estate has accepted that. There are uniform trust codes, and so there's a possibility, and that would be something to look into, whether or not there's been a uniform guardianship proposed law that's been passed. And some states, for example, some states do adopt those types of uniform laws, but it's not a requirement that a state were to adopt it. But I think that would be something to explore and shine a light on in this community.
So if you move to another state, your guardianship does stand
So
or not?
the jurisdiction would change. So if you change domicile and you move from here to, say, you want to live in the mountains and go to Colorado. So once you move to Colorado and your son moves with you, you would still have your letters from, and that's just the court order letters of incapacity, I believe, from Missouri, but you would need to go and essentially file a new petition in that state to get a transfer of that.
Transfer of guardianship.
Yeah, because it's per state. I mean,
It's per state.
yeah,
I'll be
Some
darned.
states may require
it's the state of Missouri that we've
a
got.
full hearing too
Oh,
on
that's
that.
horrible.
Almost like starting over.
So that all those expenses you pay again?
That's correct.
Oh my
Yeah.
goodness.
Wow. Well, that's news
And
to
I will
me.
say, but expense wise, like it was really, I've heard folks, and James can speak to this, like, getting charged quite a bit, but ours really wasn't. It was under $2,000 to get all the court and everything done. I didn't find that to be terribly off-putting. But I know some people, it depends on the lawyers you're using and things like that.
And their
Maybe you're
financial
paying
status.
more.
That could be.
Yeah.
Right. But I mean, I've heard some people say it's $10,000 to do it. And it's like, well, that was not what happened with us, but
Shop around for an attorney.
you have to shop around. Yeah.
But I can see how that can be overwhelming if you're like Jason and I travel continuously and we're planning on doing that. We don't have guardianship over Zion, but we would be out a lot of money if we, went to 4 or 5 different states.
Right. Well, that's good information to have. So go
And
ahead.
I was going to make a plug here. Legal services, many times, if you meet the financial requirements, and guardianship's a necessity. So, I mean, there are resources in our community that will help parents
Pay for it.
that are struggling. Yeah.
Absolutely.
Yeah.
Plus, really, there's no other way besides going through an attorney, right? Because there's a lot of information on supported decision making and all these things. But if you try to look up, how do we do this? And it just says, call an attorney.
Right.
So that is the only way, correct?
I would say that is the responsible way.
Yeah.
I would
That's right.
Good.
Good answer.
Legal advice, because you may think I need to petition for guardianship, but maybe some of these other items that we talked about, whether it's the power of attorney documents or looking for some other advocacy on determining kind of a least restrictive approach to providing care for your son or daughter. Individuals can file pro se in many cases, but again, I would highly recommend working with an attorney. Now, attorney is required for the proposed incapacitated person. So your son or daughter, if you're petitioning to become their guardian and conservator, the court will appoint an attorney to represent them and their interest as well.
And what do you call that attorney?
That's a guardian ad litem is what they are referred to.
Yes. I remember Heather explaining that when you went to court with yours. Yeah. Yeah. Okay. Can a guardian receive payment for care or support provided the individual under guardianship? Or
They can. However, I believe at least here in Missouri, there's a statutory requirement, I believe, that they have to get a court authority to receive any type of disbursement or any type of payment.
Yeah, I was thinking if you were a guardian in Missouri, you could not be a paid caregiver.
So you cannot be, the state's not going to be paying you. Now, if there's a conservatorship and there are assets there, you can petition the court to be reimbursed for your services. That you're,
I work for free.
that's how most are. But
Yes, yeah.
I was involved with a matter up in Columbia, Missouri, where I had practiced prior to moving back to Springfield. And this was not for a younger person, but for an adult guardianship, an older adult guardianship. And so this person had lived a long, fruitful life and had assets, but then developed memory issues, dementia. But this person didn't have any estate planning in place. So the only last option for them and their family, their son, was to petition the court for guardianship. But this person had $800,000 or so in, retirement accounts and in checking accounts and money market accounts. And so they had these assets that the conservator had to, monitor and keep up with and talk to advisors. And so each year the court requires you to file a settlement, essentially saying this is how much the conservator or the person, the protectee that's under the conservatorship, this is all their income they had for the year. This is all of their expenses they had. This is how many checks. You have to keep copies of the checks that the conservator writes out and provide those to the court. And so at that point in time, you would be able to petition the court and say, I spent X amount of hours and I would like a reasonable compensation for that. And most counties will have a kind of a general court rule as far as what they consider a reasonable hourly rate for those types of services.
I think one thing we're talking about too is, that piece, as well as can a guardian be a paid caregiver too? And so that, in our state, they cannot. In most programs, there might be some certain considerations depending on what that guardianship is. But when we're talking about developmental and intellectual disabilities, then they are not able to be a paid caregiver if they're the guardian.
Okay, so Elizabeth, you said that of Nathan, he's under guardianship, but it's your husband and your father.
Correct.
So can you be a paid caregiver?
With the funding in place, I can, and I am. That's it was a difficult choice that we made, but I came home and gave up my career. And it is my career now. He had that funding where we were bringing other people into the home to do that. And it got to the point that I needed to be with him. He's got a lot of medical issues, and the care we were giving, I thought, well, I would rather give up my career, come home and be paid rather than, lovely young man we had, but his qualifications, the last job he had before coming to us was stocking shelves, and I've worked, 30 years in the disability community, and I thought I could probably do a better job. Yeah. No offense. He's a great guy.
Right. But it takes a lot of time and energy talking to the caregivers and explaining and going, it's a lot.
And for us, no one told us. Literally, no one told us through this whole process that I could even, because I retired early and we planned for 15 years for me to not have a paycheck. So no one in the process ever said, well, Heather, if one of you is not a guardian, then you could have quit earlier and taken care of him instead of having, staff in my home 40 hours a week while I continued to work.
That's only over 18 though.
Yeah.
So,
Well, I mean, he's almost 24.
So,
So your support coordinator never told you, or you?
No one ever mentioned that ever until I think I learned that information this year from another mother who had moved here from Texas. I think it was Texas. And she could be the guardian and the caregiver. And then she moved to Missouri and she was kind of complaining about it. And that's the first time I'd ever heard of it.
I'll be darned.
Yeah.
Yeah.
I guess I wasn't hearing the local gossip.
Well,
I'm too isolated, people. I should have got out and learned some more stuff.
But it hadn't been our plan for a long time. I didn't really know, and it was a really hard decision.
Oh yeah.
I felt like I was abandoning him. I wasn't taking responsibility for him. That I was taking advantage. Well, I would do it for free. But I did give up. We raised 5 kids.
We have to survive.
We have a lot of, a lot of things going on here.
Right.
And I know somebody once asked me when we were talking about the older kids and they paying for their own college, and they're like, "Well, didn't you save?" And I was like, "Are you kidding? I could have put about 6-7 kids through college already with the amount we've spent on things." So it was, but it was still a hard decision.
Yeah, definitely.
But it is legal. And I mean, parents should know that option.
I mean, I'm not going to undo what I've already done. But yes, if I'd known that, we could have at least considered that early on.
I know a family in the area who did do that.
Yeah, lots of them do.
Went and terminated the guardianship so that mom could be paid.
Well,
Yeah.
I also think it's for continuity too, because if you're having so many caregivers come in and out of your house
Yeah.
and they get attached.
We all know they quit. and
Yeah.
have other-
I mean,
Yeah, and that was part of it too. We just couldn't keep enough.
Yeah.
There just wasn't enough, that could handle his level of need. But yeah, we were without a lot of times. So.
Right. So James, trust questions. What is a special needs trust and how does it differ from like a regular trust?
That is a great question. And so I'll start off maybe with how individuals may use names for trust. Sometimes a special needs trust may be referred to as a supplemental needs trust
Okay.
or a supplemental care trust, sometimes even a spendthrift trust. But in this case, the way we're using special needs trusts, it's a trust that's established usually for an individual, a beneficiary, who is receiving public benefits such as either MoHealthNet or Medicaid here in Missouri, or supplemental security income through Social Security Administration, that are needs tested or asset tested programs. And so those types of programs have essentially, you can only have a certain amount of resources available to you. There's all sorts of rules, and some of you there may be very familiar with those programs, and maybe your children are receiving SSI or MoHealthNet. And so since it's this asset tested program, for many of these people, you can't have more than $5,000 in your name as an available resource. And it differs between states as well with Medicaid qualifications. And so essentially individuals, parents are able to set up a trust for the benefit of their child, but it needs to be set up in a certain way that you are not supplanting those public benefits, but you are basically providing supplemental support. So if Medicaid isn't covering cost of glasses, or if there's dental expenses that Medicaid doesn't cover, then the supplemental needs trust or special needs trust can be used to cover those expenses. Or maybe your son or daughter may need a new television, and so you can use the trust to purchase a television. So they can be complicated and burdensome to administer, because SSI, that supplemental security income, there's a lot of rules regarding what can be used and the type of disbursements from a trust that you can make, so you're not inadvertently causing the beneficiary to lose their benefits. And so that's the biggest concern with administration. These types of trusts can be what's called self-settled, meaning the beneficiary creates the trust themselves and they fund it themselves. The best example of that may be a car accident or something like that, or personal injury award where the person becomes incapacitated, and they receive this big award in a settlement or whatnot. And so they can use that to fund this trust for their benefit, and there's certain rules regarding that. Or parents like yourselves, you want to be planning ahead. One of the only guarantees in life is that we all are going to die. Mm-hmm. And so what's going to happen
and
to
taxes.
our money? And taxes. And taxes. And so what's going to happen to those assets? And so there's a lot of planning that can go into place, and there's a lot of creativity with trusts. And so it's important to work with a qualified attorney who handles these special needs trusts on a regular basis, because there are a lot of rules and regulations regarding them. And then to understand who do you want to name to be managing those assets and making those decisions upon your passing. Being a trustee is not a fun thing for an individual, because there are a lot of requirements, a lot of duties you owe to the beneficiary or multiple beneficiaries. And so I work for a corporate trustee, but even corporate trustees for these types of trusts, there's a higher level of risk with these types of trusts. And so usually a lot of corporate trustees, we're now seeing they're not coming in to take on these types of trusts unless they are $3-5 million type of relationships when they come in. However, there are organizations like Midwest Special Needs Trusts. They are based out of Columbia, Missouri, where they are set up a little bit differently. They're referred to as a pooled trust, but you're basically able to use their services as a successor trustee to qualify as a special needs trust and ensure that your son or daughter will not be losing benefits, and they will do the administration of the trust for you. So they are complicated, but serve a tremendous purpose. One of the things as a trust officer that I'm seeing a lot of in the last couple of years are trusts that are set up to kind of have this special needs trust as a backstop. So not all people with autism or disabilities really require, or they may have the resources and have health insurance, and they may still be able to work some and have income coming in. So maybe they never actually qualify for a special need or for a Medicaid or supplemental security income. Mm-hmm. And so if you were leaving them assets in a trust, money in a trust, and it's set up with very strict language on, you can only pay out for these supplemental needs, then potentially you're not leaving them with assets that they can use because they may never actually need to qualify for benefits. And the only time they could receive those funds is if they are qualifying for benefits. Mm-hmm. So we're seeing a lot of flexibility being drafted into documents now that only trigger those special needs trust provisions inside the document if and when that person is qualifying for public benefits.
Wow. Okay.
So if and when they get SSI or something is what you're saying.
Correct.
Is that what you mean? Okay.
That's really good to know, because we actually have a trust, but we did not name. Well, I'm blowing the news here to Zion right now.
You have a regular trust.
We have a regular trust, and we did not put him as a beneficiary because we didn't think that he could handle having that much. Because we have quite a bit of assets and if Jason and I passed, we didn't think that it would overwhelm him, or he would go on a shopping spree and he would buy up every Atari box in the US. So we were thinking about changing that to a special needs trust, but he doesn't get SSI. He doesn't get any public assistance. So should we just put him as a full beneficiary and put some limitations on that?
So trusts are very flexible estate planning tools. But that your question is very valid, and one that I hear quite a bit. How much should be left to a child who has a disability? And then your comments as far as maybe not wanting to make them a beneficiary because of a lack of responsibility or ability to handle money, and they're going to spend through it so quickly. I hear that a lot. There are ways in drafting a trust document, though, that you can add added layers of protection for a beneficiary. For example, you could leave it in trust for the benefit of the beneficiary and have a trustee overseeing the assets, and that trustee then can make discretionary distributions for health, education, maintenance, and support. And you can even tighten it up even further, or you can make it more broad that the trustee is able to make distributions for their custom manner of living. But it falls on that trustee to be managing the assets, and then using their discretion of when and how to make disbursements.
Okay. So we were just hoping, we just told Hannah, his sister, we said, take care of him. That's what we did.
Yeah.
And here.
Go ahead, James.
So my comment on that would be you are putting a little bit of a burden on the other child to make those decisions. And if you were leaving all of the money to one child and saying, hey, we're giving you this money, but we want you to take care of your brother in this situation, then once they inherit that money, that's theirs. And so as they start making distributions or making payments on behalf of their sibling, they're now making gifts of their money. And so they may run into potential gift taxes.
Yeah. Oh, that's a good point. Thank you.
Yes.
So again, you can do that same thing, but by just leaving it in trust. So just amending your estate plan to make your son a beneficiary. And maybe you don't want your daughter to be the sole trustee because it can be a lot of work managing these assets and investments and determining whether or not to sell a house or other farm.
She's not the trustee, but
Okay.
I just was thinking that she's going to get a large portion of she has to split it with her brother as of right now, but we're planning on changing that. We made it during a time when we knew that Zion was not able at all, like 5 or 6 years ago. And now he is much more competent to make those decisions. But yeah, I think I'm going to change that tomorrow.
Yeah, which is a good point. We were told to update it, every 3 to 5 years, James?
I encourage everybody every 3 to 5 years, or if
things change.
Things change. Or the big D's, death, disability, and divorce. If any of those 3 things are impacting any of kind of the interested parties in your plan, whether it's children or parents or spouses, that's a good time to pull it out as well. But generally every 3 to 5 years, because other than death, the only certainty is, and taxes, I guess, would be change.
Right.
Everything's always changing.
Right. Wait, before we wrap it up, we have a couple more questions, if you don't mind, James. So,
Sure.
Okay.
So this is Dawn. Yeah, if I could run my scenario, we don't have a whole lot of assets, but we do have something that we want to leave both of our children. So we were thinking that whatever assets we have, we put in our trust. Upon our death, we have 2 trusts, one for my neurotypical daughter. So that's going to protect our family assets from potential divorce. I mean, she's getting married, and nobody gets married thinking they're going to. Yeah. Okay. Even though we're planning for it.
We hope and pray for the best. Yes.
We don't think this. We're just planning for it, just in case. Okay. And so then my son, who does have autism, who's on the middle of the spectrum, don't want to do a special needs trust because I'm ready to say my son is working an entry-level job, but he's working consistently. He's saving money in an abled account. But I don't really want to do a special needs trust just because keeping track, like you said, sometimes it gets complicated. And does that make sense? I guess what I'm trying to say, does it make financial sense so that he has a trust? He's not going to get all the money in one lump sum. His sister is going to be the trustee of his trust. Can she monitor both trusts?
I would say absolutely. I would start with, I guess, the disclaimer of, I'm not giving you legal advice because I'm not your attorney.
Yeah.
But I would encourage you to obviously work with an attorney or professional on making those decisions. However, that is not uncommon as far as what I have seen. Being a trustee, again, we kind of joke in our industry that we wouldn't wish that upon our enemies just because of how burdensome even like a non-special needs trust, just a discretionary trust can be from a compliance standpoint if done properly. Now, there are many individuals in this area and in the country here that are trustees for some other individual. That happens a lot. And many times the reason for that is they don't want to pay for a corporate trustee to be the trustee. Many family members will do that for little or no cost. at least in compared to maybe a corporate trustee stepping in. But it is a lot of work. And then it's the struggle of kind of the biases that may be in place with a sibling who's trying to take care of another sibling. And when you're wearing that trustee hat, you're not the sibling, because you have to do what's in the best interest financially for that individual, and you owe them duties. You can't just hold back just because you're upset about how they treated you years ago. Or,
That's a good point.
Yeah, that
and
is.
you have to be able to, understand maybe you have some limitations. Maybe you're not a financial advisor, and there's a pot of money here that needs to be invested. You have to understand, hey, I need to work with other professionals and delegate some of these authorities out so that we are, not sitting in a cash account for a 10-year period earning zero interest. You have to be prudent with your administration.
Wow.
That's a good point.
Yeah, it's a good point. It's good advice.
Because there's no way Hannah would let Zion buy 100 Atari machines.
Right.
Yeah.
Right. Or like when we were setting ours up and deciding, like, we don't want someone to say, oh, hey, by the way, Conrad needs a new Corvette, you know?
Exactly.
And then they're,
Yeah.
So that, So that was good. This is a lot of great advice. I do have one question back to that special needs trust. After the special needs individual passes away and there's assets there, does the state get those assets because it's a special needs trust, Medicaid, or?
Yeah, that's a great question. So the answer to that is it depends. So if it's a self-settled trust, meaning that it was the assets of that individual when they funded it, then there has to be a payback provision. Third-party trusts don't always have to have a payback provision. So again, I'd encourage you to kind of work with your a competent estate planning attorney, special needs planning attorney. But those third-party trusts are not generally required to have the payback provisions for Medicaid.
Okay. Any last thoughts? Go ahead, Dawn. Go ahead. Sorry.
So payback, by that you mean paying back to Medicaid, not
Correct.
paying.
Correct. So Medicaid has in its laws provisions that if you receive assets and you were on Medicaid and you pass away, you are required to pay them back up to the amount that they have provided services for you.
Right.
Unlike Medicare, it is, since it's a needs program, if the program's assuming that you don't have the assets. So if you end up having the assets, then you are required to do the payback provision at the end.
Okay.
Gotcha.
So payback, it was like whatever money's left after it's been paid back to Medicaid, that does get to go to somebody.
Absolutely.
Yeah.
It would go to remainderment beneficiaries.
Okay.
Yeah. Well, this has been great information,
Yes.
James. We really appreciate you coming on. Do you have any last thoughts or words or advice or?
No, I appreciate you all having me on the call. I think what you guys are doing is fantastic.
Oh, thank you.
And again, I would encourage, anybody that's looking to set up a special needs trust or has other questions around guardianship to, work with a local attorney who has experience and practice in that area. And again, for those that are local here to the Springfield area, I'm more than happy to provide recommendations and referrals out to folks if that's a need.
Great.
Now, there is, Greene County has an estate planning commission, right, of attorneys and accountants?
Yeah, absolutely. And so I think that's a great spot to start. Legal Services of Southwest Missouri was mentioned during this call. I think that's a great place to start. There's a estate planning society here in Springfield where I believe there's probably a website for that organization as well that probably has a list of referral sources on their website.
Yeah, we could put all that in the show notes as well.
Yeah, we will do that.
Fun.
Excellent.
I'll do that.
Yeah, Heather will do that.
I'm telling Heather right now, put that in the show notes.
James, thanks again so very much. I
Thank
really
you.
appreciate your
Absolutely. Thank you for
expertise.
having me.
Yeah, we really appreciate you.
You're welcome. Have a good night. Thank you.
Guys, take care.
You too.
Bye-bye.
Bye-bye. Okay, Tara, where can everybody Find us.
Okay. You can find us at navigatingadultautism.com. We are on Facebook and Instagram at Navigating Adult Autism Podcast. Just search for us. We also are on YouTube now. At some point, we might get a camera up and we can you can see like, Heather's like looking at me like, no, we won't.
Extra makeup.
Maybe we'll just put a picture of us up while you're listening to us.
Still picture, yeah.
The best picture. And then we also, let's see, what was I talking about? You can listen to us on Apple, Spotify, and YouTube. We also are putting the autism, Don Rethman puts together the autism gossip. We've been putting it on the blog on our Navigating Adult Autism website.com website. And yeah, that's what we do.
And I wonder if anyone has any follow-up questions, they can email us and maybe we can ask James those questions.
At moms@navigatingadultautism.com.
Yeah, perfect. Okay. Thank you for listening, everybody.
Thank you.
Bye-bye.
Bye.
Bye.